Let's switch gears now. Talk about issues related to legal matters. Nigeria will go into the poll 2023 with a lot of issues that have been thrown up. A lot of them are legal issues, from the issues of Electoral Act 2022, yes, and the constitutional amendment, which now we've seen the voting in the National Assembly and anticipating voting from the state houses of assembly. Now, that on one hand, there are a lot of controversies when the president went to the National Assembly proposing an amendment to the Electoral Act 2022. But then the National Assembly had taken a move, the Senate precisely, had moved towards it and they voted against that move. Now, there was another interesting thing that happened, and it was in Ebonyi State, where a federal high court ruled that Governor Dave Umahi should vacate his office because of the defection, himself, the deputy, and some lawmakers in the Ebonyi State House of Assembly. But let's get some legal opinion now on some of these issues. I'm being joined by senior advocate and rights activist, Mr. Falana, who joins us from Ghana. Thank you so much, Mr. Falana, for joining us tonight. Let me begin and get your quick views on two issues before I take you to Ebonyi. First is on the Electoral Act. The president proposed the amendment to Section 84, subsection 12, that there must be some kind of collusion with the Constitution, that there is a conflict of that section or subsection with the position of the Constitution. What's your view on that, on the proposition of the president?
Well, with respect, I think we have left the level of debate on that matter. The Senate has thrown out the proposed amendment by the president. Whether the House of Reps does so or not, the bill is, the proposed amendment is already out. Those who feel sufficiently strong about the rejection of the bill, the amendment proposed by the president, may have to test the constitutional validity of the section in the court. But as far as I am concerned, we're either practicing democracy or not. We cannot bend the rules when it suits certain people. The National Assembly too should also not make laws to, as it were, ambush anybody. The point I'm making, when people say that the proposal, or rather the provision, prohibiting political appointees from participating or voting or being voted for in a primary of a political party is unconstitutional. Again, I think people are talking of discrimination to suit their purpose. In Nigeria, by virtue of some provisions of the Constitution, if you do not have a school certificate, you cannot contest election in Nigeria, even to become a councillor. Now, there are over 60 million illiterates in Nigeria who do not have school certificates. Nobody is protesting that 60 million people have been excluded from the political process. But when it comes to certain political appointees being restrained, being asked to resign from office if you want to participate in the primary of a party, we are saying that is discriminatory. Whereas what some of the legislators are saying, or what informed the provision, is that you may have a situation where the president or a governor may have about 1,000 political appointees who are going to be delegates in a primary. So the fear then is that the large number of political lieutenants may give certain people advantage over the others. Therefore, let us have a level playing field. Again, as I said, the bill has been rejected by the Senate. It's going to the House of Reps. But even if it is passed by the House of Reps, the bill is already out. So that's
I understand that a few persons, at least 3 or 4 that I am aware of, have since gone to court to challenge, that provision because they feel that it is against their fundamental right to vote and to be voted for. Let me take you into a very interesting area, which you voiced out in a statement today in relation to Ebonyi and the Federal High Court judgment ousting or sacking Governor Dave Umahi, his deputy, and some members of the House of Assembly in Ebonyi State. There's been an appeal to that, and there's been action by the governor and the deputy governor, and in fact the House, as members of the House. What's your view? There are precedents to this matter, but can a governor be removed in this manner?
Well, I think it was the late Lord Denny, a frontline British judge, who said that if we say something has not been done before, and therefore we cannot do it, the society will become stagnant. In this particular instance, it is the first time that the validity of votes scored by a political party, not by a candidate, is being questioned based on a defection by the flag bearer of the party. In other words, during the 2019 governorship election in Ebonyi State, about 393,343 votes were scored by the PDP. Now, on the basis of those votes, a PDP government was formed in that state for a 4-year tenure. If along the way, the governor decided, as he did decide, to abandon the PDP, the question is, has he not abandoned the mandate, the 4-year tenure? In other words, my colleagues are saying, oh, the case of Atiku has resolved this matter. With profound respect, the question of the votes scored by the PDP never came up for determination. Secondly, it wasn't the president and the deputy and the vice president that decamped. It is an Obasanjo government, a PDP government. And substantially, the president did not decamp from the PDP. It's not like a military regime where you have Buhari Idi regime or Murtala Obasanjo regime. No. We're talking of Obasanjo regime. We're talking of Umahi regime in Ebonyi State. So if it was just the deputy governor that decamped, Atiku decamped, and they said, the Supreme Court said he had his freedom of association. But please, let people not embarrass the Supreme Court or distort the facts of that case. The Supreme Court did not pass the defection or what I call political prostitution. The Supreme Court did condemn what happened. The Supreme Court did say that Vice President Atiku ought to have resigned. And even if he resigned, he has no right to criticize the positions of the government, decisions of the government of which he was a part. However, his conduct would tantamount to misconduct, and the National Assembly would deal with it under Section 143 of the Constitution. In the entire case, the question of the validity of the votes credited to the PDP never arose. As in this case, where a governor got a mandate from the people and has abandoned the mandate. Yes, my colleagues are saying, oh, the governor has his freedom of association. Oh, yes. The freedom of the association of the governor, with profound respect, has not extinguished, has not annulled the over 393,000 the democratic right of the 393,000 voters. In other words, we are practicing democracy based on majoritarian rule, not minority rule. So there is no way the vote of a governor and his deputy can annul the 393,000.
Mr. Falana, if I may quickly jump in here. So some people will argue, lawyers have argued, that the position of the Constitution is very clear on how a governor or a deputy governor or a president or a vice president can be removed from office. This, they say, is not captured in the position of the Constitution. Any other law is secondary to the position of, to the Constitution.
Again, the Constitution never envisaged. The Constitution never envisaged that a governor who has been elected on the platform of a political party will abandon the party, will abandon his mandate. So there is a new situation here.
But can anyone suffer any injury, senior advocate, can anyone suffer any injury as not prescribed or captured by any law in the land, especially the Constitution? The Constitution has made it clear that nobody will suffer any injury for any offense that is not captured by the law.
Nobody has suffered an injury here. What the governor ought to have done was to resign from office, having abandoned the mandate, having cut short his tenure, because we are practicing democracy, where the governor refused to quit. As in this case, the court can order him to quit, because what he has done was never envisaged by the Constitution. And there is no constitution in the world that will capture all eventualities or circumstances. And this is not the first time in the history of Nigeria. It's not provided in the Constitution that if there is a rerun election, a governor who won the same election, who was in office, participated in a rerun election, and now won, nowhere is it stated that the governor will complete his term of office. But if some lawyers argue that once the governor wins, he starts a new tenure. The Supreme Court said no. In the case of Obi and Ngige, in Anambra State, it was never in the Constitution that if somebody didn't win election, spent 36 months. Many lawyers argue the winner of the election, Obi, would then complete the term. I said, which time? And the Supreme Court so held that the moment Governor Obi took his oath of office, his tenure will begin to run. It's not provided in the Constitution, by the way.
A lot of people, son advocate, a lot of people will also make reference to Abegunde case. But we just have 30 seconds to close the program, Mr. Falana. The case has gone to our appeal court. It will be interesting, isn't it, to see what the Supreme Court will say as a court of finality in the land, isn't it?
No, I think it's going to get to the Supreme Court. And I do hope that this time around, we are going to put an end to political immorality in our country, whereby if you are elected on the platform of the party, you can vote for votes, and if the party abandon that party, you have abandoned your party, and you must go in. And unless we do that,
thank you so much.
We're not going to put an end to impunity in the land.
Thank you so much, Mr. Femi Falana, Senior Advocate of Nigeria, speaking to us from Accra in Ghana. Thank you so much indeed for giving us your views or your legal position on this matter. Thank you so much indeed.